What are restricted stock units, RSUs, worth in divorce? Imagine a piece of your compensation that's tied directly to your company's stock, but only becomes yours after certain conditions are met. That's what restricted stock units are. They are a way companies reward employees with shares of stock that are granted but not fully owned until they vest. When you get divorced, figuring out what these RSUs are worth can seem complicated, but understanding the basics makes it clearer. RSUs granted during the marriage are usually considered marital property, which means they are part of the property to be divided. If RSUs were granted before the marriage or after separation, they might be considered separate property, depending on where you live and the specific circumstances. The key point is whether the RSUs were earned or granted during the marriage. Next, you need to look at whether the RSUs are vested or unvested. Vested RSUs are fully owned by the employee and can be sold or transferred. Unvested RSUs are still subject to conditions like continued employment or performance goals. Both types granted during the marriage are generally considered marital property, but unvested RSUs are uncertain because they might never vest if employment ends. Valuing RSUs depends on the stock price at certain times, like the date of divorce filing or the valuation date. If the company is publicly traded, you can use the current stock price for a straightforward valuation. For private companies, it's more complicated. You might need to estimate the value based on recent funding rounds or internal appraisals, which are less precise. Tax considerations also play a role. RSUs are taxed as ordinary income when they vest, and capital gains taxes may apply when you sell the stock. These taxes reduce the net value of the RSUs and should be included when dividing assets. When it comes to dividing RSUs, there are several options. The stock can be sold immediately and the proceeds split. Alternatively, one spouse might keep the RSUs and pay the other their share in cash. Some agreements divide the RSUs when they vest or are sold later, which is called deferred division. Another approach is asset swapping, where the non-employee spouse receives other marital assets of equal value instead of RSUs. Courts often use formulas to determine what part of the RSUs is marital property, especially when RSUs are part of ongoing compensation. The Powell formula, for example, considers how much of the RSUs were earned during the marriage versus outside it. There are risks involved with dividing RSUs. If you choose deferred division, the stock value might go down or the employee might leave before vesting, risking forfeiture. Immediate division might miss out on future appreciation if the stock price rises. In family law, the goal is to divide marital property fairly. With RSUs, that means understanding their value, timing, and tax implications. Often, legal and financial professionals work together to make sure both spouses get a fair share. Proper documentation, clear understanding of the RSU plan, and considering tax effects are all important steps to ensure a just division.